Well, I'd like to welcome everybody who joined to this Oxford webinar on inventions generated by artificial intelligence and what implications that could have for the patent system. Our speaker today is Professor Adam Jaffe from Brandeis University, who will shed an economic perspective on the question. The work that Professor Jaffe undertook on that issue was done together with his two co-authors, Melissa Weisman and Gaetan Rassenfosse from Switzerland, EFPFL, and Melissa Wasserman is University of Texas, the law school. So Professor Jaffe has an amazing background. He was educated at the top schools in the United States at the MIT and Harvard, and he has published way too many papers that I could possibly even cite them all. So let's just say he has published a lot. And he's also offering courses on quantitative people for non-quants people, in case anyone is interested. So the topic of artificial intelligence and the implications for the patent system, I think sounds a bit like science fiction, where we have some computers creating new perspectives. Can non-humans own this intellectual property? Who will own that? My favorite association with that remains the selfie of the monkey in the jungle, where it was eventually ruled that the monkey cannot own his own selfie after years of copyright dispute. I wonder if there's any parallel to that issue here now. So for those who do not know Oxford, which I hope is not the case for anyone on this course, but you never know, Oxford was launched in 2011 by academics from the University of Oxford who thought that the research into the economics of IP is too important to be just shared with a scholarly audience. So we went out there and shared our perspectives and views on IPnomics to business, to governments, to policymakers, to industry, to whoever was interested in that. And we preached the holy gospel that intellectual property is not just about the law, it's also about the economic implications and the economic value proposition it has. And in our opinions, actually, that's incredibly important aspect of IP. And that's been ages ago, and we keep continuing that. So we're Oxford based, we are still working in close collaboration with our colleagues in Oxford University. And we also have now a place in London. And we care about the value of IP, the damage calculations around IP, the possibility to extract the maximum value from IP, to look at the policy implications if certain choices are being made and what that means for society, for growth opportunities. How can countries develop a certain competitive advantage on the basis of IP? All of these issues are of strong interest to us. Over the last couple of years, we have been working a lot on standard essential patents and also on the economics of copyright. With that very super short introduction, if anyone is interested in getting involved or wants to give a webinar presentation or write a short article for our blog, very, very welcome to do so. Thank you for joining us all at such short notice. We only came up with that idea 10 days ago. We thought we should do it. And we were extremely happy to see such a strong interest, given how little time we gave everyone to join the call. With this very, very short introduction, I give the floor now to a super prominent speaker, certainly having interesting perspectives on that. And let me bring up his PowerPoint presentation.
So I'm going to share from my screen, Roya.
Okay.
You'll just stop sharing.
Stop sharing 1 second. So then I need to make you the presenter, right? Multiple. No, you can just share it, I think. Perfect. Adam, thank you very much. This is very helpful.
Do you see the presentation?
Yes, perfect.
Okay, great. Well, thank you very much for that introduction, Roy. It's great to be here. As Roy mentioned, I've been working on this. It isn't really a paper yet. We're still just kind of working on this. So I'm very interested in getting your ideas and your reactions to some of the thoughts that we've been developing here. So let's go. Basically, here's where we're coming from. We believe that AI systems either already are or will soon be making inventions. And we don't think the patent system is ready for this. So what we're going to try to do is to think about what economic analysis and what we've learned from sort of other possibly analogous challenges tells us about this. And our goal really, as I said, is to kind of identify the issues and provoke some discussion. I'd be willing to bet that everyone listening to this will disagree with something I'm going to say in the next 20 minutes, and that's good because we can talk about it. And as I say, this is based on my work with my co-authors, but they're not responsible for everything I'm going to say today. So if you think something I'm going to say is particularly crazy, don't blame them for it. Okay, here's where we're coming from. This is not about using AI to draft patent applications, which is also something that is getting a lot of attention these days, trying to write the application for a given invention in the way to make it most likely to be granted using natural language processing and machine learning. But that's not what this is about. What we're about really is that we think that the day will come, we're not quite sure exactly how soon, when AI algorithms, machine learning algorithms, which I'm just going to call a machine. I'm just going to use that word machine because I don't want to be too specific about the nature of the AI that's doing this. So I'm just going to call it a machine, that machines will be making inventions. And then once we have such machines, making inventions is going to be very inexpensive. It's going to be close to zero cost to make an additional invention. And that it's not really going to be possible to tell just by looking at the invention itself, whether it's a machine invention or a human invention. So that's kind of the perspective here. If you reject those premises, then you're probably not going to be very interested in this talk because those are kind of given for this talk. Now, the other thing this talk is not about is whether under current patent law, you can, in fact, list a machine as the inventor on a patent application and get a patent. That is being debated. Most countries have said no. They have rejected applications that have been made with machines as inventors. And my reading of the discussion around that is that that is probably correct in the sense that under current patent law, that's probably the right interpretation. But that's not an interesting question to me. The question that I'm interested in is if we think about the goals of the patent system and patent policy, what we're trying to accomplish with the patent system, would it be a good idea or not a good idea to allow AI inventions, machine inventions to be patented? And more broadly, what are the consequences of the patent system that this is going on, whether we allow those or not? So a lot of what I'm going to be talking about today would require changes in patent law. I'm not arguing that any of what I'm talking about would be legal today, but it's more about what maybe we should do. So here's an overview of the talk. I'm going to start by saying, how do we think about the underlying goals of the patent system in relation to machine patents? Then I'm going to discuss this question of whether machines should be allowed as inventors on patent applications. Then I'm going to talk more generally about some challenges that the existence of machines who can invent create for the patent system. And one of the things I'm going to say is that those challenges don't go away if you just say, well, we're not going to allow those inventors on patents. Some of those challenges are still going to be there. And then I'm going to talk a little bit about some ideas we have to deal with some of these challenges. And this is where sort of the crazy ideas come in. And our goal here is to just start some new thinking about some of these issues. We don't really believe that these are necessarily the right answers, but they're possible answers, and hopefully they'll generate some discussion. Okay, so let's think about this issue of if we've got patents that are created by machines, how does that relate to the goals of the patent system? Well, of course, the first goal of the patent system is to employ patent attorneys, right? No, I don't really mean that. That was a joke. So we won't deal with that. We won't talk about that. So one goal of the patent system is to incentivize invention, to give people incentives for inventing things. Now, I've said that the marginal cost of inventions from these machines may be very low. So you might think you don't really need incentives for machines to create patents if they're close to costless. But the machines themselves are expensive to develop. So you might think that you still want to incentivize invention. You want to give people incentives to create these machines to begin with, to write these algorithms that are going to be good at inventing. Now, another goal of the patent system, I would argue, and I believe that this is underappreciated. Many people think of patents as mainly about giving people an incentive to create, to make inventions. But from an economic perspective, I would argue it's probably even more important that what patents do is they protect investments in developing the invention into a marketable product or process. So if you think about testing, for example, new drugs to make sure they're safe, scaling up production, the other things you need to do in between having a patent and making money, that requires investment, and patents protect that investment. And that is an important aspect of what patents do. If you think, for example, of the Bayh-Dole Act in the US and other analogous policies in other countries that allow universities to get patents on inventions that come out of basic research, that isn't about giving people an incentive to invent. For the most part, those things have already been invented. What it's about is creating property rights so that people can spend the money necessary to get those inventions from the invention stage to the market stage. And that's, I would argue, is going to be just as important. I mean, it's possible that maybe someday AI will be so good that it'll do everything. And an AI invention won't even need to be tested because we'll know how good it is. But that seems unlikely to me, at least in the foreseeable future. So I think this second person purpose of the patent system will remain important. And that's going to be a theme throughout the discussion here. And then finally, a goal of the patent system, I would argue, is to be predictable and fair. And I think the fact that the inventions that come from machines really look the same as the inventions that come from humans have implications if we want the system to be predictable and fair for how we treat them. And I will come back to that. Okay, so as I mentioned just briefly, the current state of play is that patent offices around the world have basically said you can't submit a patent application where you list an AI algorithm, what I call a machine, as the inventor. And most people seem to think that this is probably, under current law, going to be the answer. But as I've said, that's sort of not what I'm interested in. What I'm interested in is what do we think we should do if we want to achieve the goals of the patent system. So I'm going to say that is a bad outcome. We don't want to just say no to machine patents. And there are a couple of reasons for this. I don't think it's consistent with the goals of the patent system, because even if we don't need an incentive to develop the machines, we still have this problem that people need a way of protecting the money that they're going to spend after they get the patent or after they've made the invention to turn something into an economically valuable product or process. And so if that's the goal of the patent system, the fact that it came from a machine really shouldn't matter. In addition, I really don't think it's practically sustainable to say that you can't have machines as inventors, because if you do, what's going to happen is people will put human names on the application. And I think in the vast majority of cases, there's going to be a human who can be identified as the inventor if that's what you need to do. Because there really isn't a clear line between having an invention where you were helped by a machine, which everyone agrees would be patentable, and having an invention that came from the machine itself. In fact, in the German patent office, when they rejected the application that was made with the machine listed as an inventor, they basically said, look, you could have just listed the human who was working with the output from the machine as the inventor, and then it would have been granted. So I don't think it's really logically consistent if we're going to say, we can't really say machines can't be inventors, but then we're going to reject an application because we're going to say that the human name that's on there isn't the real inventor. It really came from a machine. Well, if it really came from a machine, then the machine is the inventor. And if it didn't really come from the machine, then the human is the inventor. So, I think it's going to be very messy to try to say ultimately that these machine inventions, you can't be patented. Now, again, I'm not disputing that under the existing legal concept of an inventor, that might be the right outcome. I'm just saying, I don't think it really makes sense. Now, a slightly different argument, which some people have made, is putting aside the question of whether we just say the machine is the inventor or we find a human name to put on the patent. Some people have argued that we should sort of think of machine inventions as kind of a new kind of intellectual property. We should come up with sort of a new kind of protection, maybe a new category of patents, or maybe something completely new. There was this comment in Nature earlier this year that made this argument, basically saying, look, these are really different. They're very inexpensive on the margin to make. So the incentives aren't the same. Our concerns about, natural humans and so forth, they really should be treated differently. And I think it's legitimate from a theoretical perspective to make that argument. I think that you really can't reject that argument, that from a theoretical perspective, there would be reasons to treat these things differently. So you might want to charge higher fees, for example, or give them shorter terms, or perhaps impose a FRAND requirement on all machine patents, regardless of what kind they are. And I think you can make those arguments reasonably, but I'm going to say, I think as a practical matter, that's going to be really hard to do. And our experience with trying to make certain kinds of inventions be treated differently isn't very good. So once again, if we create a system in which a machine invention is sort of discriminated against, either it's more expensive or it doesn't get as good property rights, what's going to happen is that people are going to conceal the role of the machine in the invention, and they're going to find ways to describe the invention as having been human generated. And yes, you can say that that's not allowed, and you can have sanctions for, improperly identifying the human as the inventor, but it's going to be really hard to do, I think. And our experience with sort of drawing lines and treating different kinds of inventions differently isn't very good. One example of this is the US PTO about 20 years ago was worried about business method patents being granted that shouldn't have been. And so they created a special extra review for business method patents. And what happened is people found ways to write their applications so that they could be classified not as business method patents to avoid that burden. And I think the ability of the applicants to get around our attempt to discriminate is likely to overcome the benefits, the theoretical benefits, which I don't dispute, of possibly treating these differently. So I think that that's probably not a very practical way of looking at it. So basically what I'm saying then is I think we should allow patents from machines, and we should not create a separate track for them, but try to deal with them within the existing, or not the existing, but within the same system as we deal with human patents. So now I want to shift gears and talk a little bit about other implications that that's going to have for the patent system. And the first one to think about is, well, what is the obviousness standard? How should we think about that in a world in which machines are making inventions? So I'm guessing that most of the people on this call are familiar with the obviousness standard, the notion that you can't get a patent on something if a person who has ordinary skill in the art, the so-called PHOSITA, could have come up with the claims that are in this patent based on previous technology. If that's true, it's obvious and not patentable. But even under current law, when we look at these people with ordinary skill, it's not limited to patented inventions, it's any inventor. So even if we say machines can't be the listed inventor on a patent, we would still have to address the question of, well, if they're making inventions, are they part of the potential inventors that we think about when we try to figure out if an invention is obvious? And I think that's a big issue and potentially quite problematic, because if you think about a world in which these machines are really spewing out a lot of inventions, you've got a well-trained deep learning algorithm that can search for and find, lots of different inventions, then in some sense, you could say it's always going to be the case that any invention could be found by some AI routine. And since these invention machines are sort of potentially a very broad and diverse kinds of things, figuring out in a particular case whether there might be a machine that could have invented something that, say, a human inventor proposes, and saying it's obvious because a machine could have found it, I think is going to be very problematic. At best, it'll be messy. And at worst, it might end up in a situation where essentially all inventions are obvious, and therefore nothing could ever be patented. And so while it might seem a little inconsistent to you, I don't think it is inconsistent. Where we come out on this is to say, we think you should be able to include machines as the inventor, the listed inventor on an application. But on any application, whether it comes from a machine or from a human, when we're trying to figure out whether or not it's obvious, we should only think about humans. Was it obvious to humans? We shouldn't try to figure out whether it was obvious to machines, because I think ultimately that's not really a workable standard. And this, if you think about this, you'll start to think, well, maybe if everything is obvious, then what are patents about at all to begin with? And I'm going to come back to that question at the end of the talk. So here's, a way that we've been thinking about kind of how AI is going to affect just the whole world of inventions and patents. So the way, this is crude and metaphorical, but go with me for a minute here. So think of there being some set of existing inventions, which either we've already got or else they're obvious, one or the other. And the arrows indicate that set, of course, is growing over time. But at any given moment, there is a set of existing or obvious things. And then there's some things that are just impossible. Like nobody, no matter how hard they try today, can invent a spaceship that'll travel faster than the speed of light. That's just not possible. And then there's a range of things which we can think of as sort of the potential new inventions. They're close enough to what we've already done that somebody could invent them, but they're not yet in existence or obvious. And currently with humans, we sort of go fishing in that yellow area at every moment in time. We go looking for possible inventions we can make that are possible, but have not yet been made. And those are the potential patent applications. Now, how many of those we find in any given period of time sort of depends on human ingenuity, and it depends on the resources that are devoted to invention. The more we try to invent and the smarter we are, the larger the sort of fraction of the yellow area we'll find at any given moment in time. Now, when machines join this search, what's probably going to happen is a much larger fraction of the yellow area in any given period is actually going to be found. So if there's some set of inventions that could be made in the next 6 months, humans find some of them, machines are going to find more of them. And therefore, probably what's going to happen is if we do allow machine inventions to be patentable, there's going to be an increase in the number of applications, and that maybe it could be a big increase. So that's a problem, potentially, because patent offices already to some extent struggle to keep up with the examination burden. And this is going to make it worse, and potentially much worse. Now, the examiners could use AI in the examination process, which would help, but probably the private sector is always going to be ahead of the government if you think of it as a race. And politically, it doesn't seem likely that we're going to let algorithms, make the entire decision, completely delegate the examination decision to an algorithm. So there'll be a need for humans. And so I think there is a danger here that patent offices are going to be sort of overwhelmed and not have any way of catching up. And that's a concern. So we have a thought experiment we suggest people think about. So we've said that we don't want to impose different treatment on machine inventions. We don't want to have one door that you go through with human inventions, and if you have a machine invention, there's another door that you have to go through. But suppose what we did was we created a new track which was optional. So it was up to the applicant whether they want to go through this door or not. So we don't have to worry about whether we can tell which are which, because they'll just decide themselves, do they want to do this or not? But this new track is one that might be potentially attractive to people who have machines that generate inventions. And the idea is that if you've got a machine that generates inventions, so think of what is that? That's like a machine learning algorithm that produces ideas for patent applications, which are in fact novel and non-obvious and meet the other standards for patentability. We've got an algorithm that sort of spits out such things. So what we could do is we could say, okay, if you've got such a machine, you can bring it in effect to the patent office. And what the patent office will do is, instead of examining individual applications, they will examine the machine, perhaps by examining a bunch of its outputs and how it works. And they will determine whether the machine is in fact a valid patentable invention generator. And if they decide it is, then you don't have to submit your individual patent applications that come from that machine. They would automatically be granted. So this is, as I say, a pretty radical idea, but it's a way to start us thinking about how we might deal with this idea of machines that can invent. And the argument here is that because this track is optimal, we could assign different property rights and fees to it. So we could, for example, charge a lot of money to get your machine certified. This could be a major revenue generator for government, that if you want to get automatic patent grants, you bring your machine, you pay a big fee, and it gets approved, and then everything it generates is automatically patentable. At the same time, we could also put limitations on the property rights that are associated with the patents that are granted this way. If it's coming out of a machine, maybe it shouldn't last as long or be subject to other restrictions. Now, finding the right combination of fees and rights limitations that would make this politically acceptable while at the same time still being attractive to applicants is obviously not easy to do. We're not claiming that this is straightforward. But the thing is, if you could do something like this, everyone would benefit. Even the human inventors who don't have access to a machine would benefit if the patent office is unclogged, because they can deal with the machine patents in this more efficient way. So in principle, this could be possibly sort of a win-win way of dealing with the potential flood of patents. So we think it's worth at least sort of thinking about that idea. Okay, then the last thing I want to talk about, I'm really going to go out on a limb here and think about this in the extreme. So let's go back to this picture. And what if we get to a world where basically at any moment in time, these AI machines find everything that could possibly be invented at the moment. Everything that is feasible, a machine finds it at low cost. Now, I'm not saying that's going to happen tomorrow, but it could happen eventually. What would that mean for the patent system? So what would be the role of the patent system in that world? It doesn't seem like incentivizing invention is very important anymore, because we're getting every invention we could possibly get, we're getting. So we don't need to incentivize invention, but we would still need to protect development investments. You know, if it were possible for machines to identify costlessly every drug that current scientific understanding tells us might help with any disease, we might still need to test them to like make sure they're safe and work and so forth. And someone would have to spend money to do that. So how would that work? So this patent system isn't going to work because priority has become sort of irrelevant. But we might still want to have some kind of a system. So again, just to generate some thinking about this, patents incentivize invention and they protect these development and investments. We no longer care about we no longer care about getting inventions because we've got them all, but we still want to have some way to protect these development incentives. And we can't do it based on who comes up with it first, because they're all there. Everybody's got all of them. So we can't do it based on priorities. So it's not going to be a patent system as we know it. Here's an idea just to sort of, again, stimulate thinking about this. We could create, I call it a purchasable exclusive development right. So think about this world in which like every drug that could possibly be invented, everybody knows what they are. We're just not sure which ones to actually take to market. What you could do is you could come and you pay a big fee, and this goes to the general treasury. I think of this as like a way of raising money for the government. And you buy an exclusive development right. I wouldn't call it a patent, but it's a little bit like a patent. You wouldn't have to prove non-obviousness because nobody could prove non-obviousness. Everything is obvious basically at that point. So that would not be relevant. The only thing you'd have to do is say, well, no one else has previously bought the right to develop this opportunity. So I'd like to do that. I'd like to pay, $100 million to the government for the right to develop this particular drug to treat Alzheimer's. Now, again, it's going to be tricky to figure out exactly how this works. Do you have a fixed fee? Is it $100 million regardless of what opportunity you're trying to come up with? Or is it depend somehow on the size of the opportunity? That would be complicated to figure out. But we're just trying to push the idea here that what we should be doing is thinking about what we're trying to accomplish, not just arguing about like, what does the current law say about AI patents and how do we fit them into the existing system? Okay, so I'm done. Let me just wrap up with kind of a extended metaphor here. So my metaphor here is this train is probably coming, and if just trying to sort of blow up the tracks so it can't get here is not desirable, and it probably wouldn't work even if you tried to do it. The existing train station or stations we have aren't going to be very good at dealing with this train. We could say we're going to have two different kinds of stations, one for the old trains and one for the new trains, but I think that's going to be not work very well in practice. So what we need to think about is how do we redesign the station that everybody uses so that it will fit this new world with this new kind of train. And in trying to do that, we should focus not on like, how does this train relate to the existing system? We should think about what are our goals in the existing system and how can we best meet those goals with this new thing, this new kind of train. So I'll stop there. I'd love to hear other people's thoughts, and happy to, if you don't have a chance to get your thought in this hour, feel free to email me and we can talk about it some more. So should I stop sharing? Maria, what do we do now? Are you going to
Can you hear me?
Now I hear you, yeah.
Yes, no, thank you very much for this really interesting question. We had already two people raise their hand. Let me see. Okay, Olga Gurgula and Matt Hervey asked their questions. You know what, Olga and Matt, I'll just unmute you so you can just raise your question. You just need to somehow get rid of your, unmute your phone. I'm also gonna do the same for, oh yeah, Olga, you have the floor. Please ask your question.
Thank you very much. Thank you very much to Professor Straffer for your extremely interesting presentation and a lot of thought-provoking new ideas. I completely agree that the patent system as we have today is not fit for protecting AI-generated inventions, because if you think about the way the patent system is designed, it is designed around inventor as a person, person skilled in the art is a person. The different theories that we apply, the courts apply in terms of analyzing inventive step, also in terms of how the person would react to the obviousness, right? For example, whether there is a motivation to find a particular invention, whether there are specific pointers in the prior art to find an invention. So these are all theories developed around a human inventor, and person skilled in the art is an inventor as well. So I completely agree with you that we need to adjust the patent system somehow. And maybe the idea of splitting human inventions and machine inventions into different sets is a great idea. And I will need to think about your very radical, as you said, suggestion in terms of providing certification to the machine generation. So that's really interesting. And you mentioned that there is if we imagine in the pharmaceutical industry, in medical industry, that all drugs are being found, right? So how do we incentivize further development of the drugs? I think for the drug system, there is a very good incentive already in place in the form of marketing authorization.
Yeah.
So if a company invested a lot of money in clinical trials, in preclinical trials, clinical trials, then they would apply for marketing authorization, and this data will be protected for a number of years. And it's a very strong protection in the European Union. It's 8 years plus 2 years and potentially plus 1 more year. So it's a quite a long term of protection when other competitors are not able to use this information. So maybe for this type of inventions, we would not need any additional protection in this sector. So potentially thinking about the equivalent type of protection in other sectors, maybe something to think about. What do you think? And thank you.
Yeah, no, I think that's a good point. And what it basically, to generalize your point, I mean, I was using drugs as one example because I think it's easy to visualize. But I think to generalize your point, the question it raises is if we agree, and maybe you don't, but if we agree that mechanisms to protect these, I'll call them development investments, broadly speaking, is desirable, I think it's a legitimate question to ask whether the best way to do that is with a generic development protection right of the kind I described, or whether it would be better to think about sort of case by case specific mechanisms, such as having one for testing data and one for, you can imagine building big factories also requires typically government permits of various sorts. So you could conceivably imagine a system in which to get the environmental permits to build a big factory, you'd have to get a development right, and that would be potentially exclusive for some period of time. So I think it's a legitimate question to ask. What are the best ways to do that? I would just like to keep on the table the notion that even if we don't worry so much about invention anymore because it becomes really easy when these machines do it, we should still think about that development issue as a policy concern.
We have another question from Matt Hervey. Please ask your question, Matt.
Thank you very much. I thought it was a fantastic talk. I hadn't heard that suggestion before. Just one comment on how to price for monopoly. I mean, an auction would be one mechanism.
Mm-hmm.
And then just some other comments. First of all, you're sort of going full circle to the use of early monopoly rights in the UK, or well, England at the time, where you would actually get a gift from government either for favourites, so you'd have the exclusive right to sell playing cards, not that they are inventive, but you get an exclusive market, or you would know a novel way of making stained glass from another country, and you get the exclusive right to exploit it within England. So I think that's all in line with the history. And what I've been saying, yeah, go on.
No, I was just gonna say you're absolutely right, and I didn't go into that just out of interest of time. That the notion that the person who gets what we now call a patent, or what you would call a patent, is based on an invention priority rather than just the whim of the sovereign, came along after the first use, as you've described, of these exclusive rights. And what I'm basically saying is, if we move into a world in which priority becomes sort of irrelevant, as you say, we are sort of full circle. Ideally, we wouldn't be giving them out based on who the king likes.
Indeed.
We would be giving them out based on some other mechanism. And I think your point about an auction is certainly worth thinking about. But I think that's the key here, is that we've been for a long time in a regime in which we only think about these rights in the context with priority of invention. It's almost like that's become synonymous with the granting of these exclusive rights. And the point I'm making is that that may not be right going forward.
I had a couple of other points. Certainly, the danger zone we've been worried about in the medium future is inventions which can be readily reverse engineered but cost a great deal to develop.
Mm-hmm.
And the two examples of drugs, as you were saying, where the cost of bringing a successful drug through clinical trials can be in the billions of dollars, but if it's a small molecule, could be reverse engineered very quickly. The other one that's been suggested is novel alloys. So in aerospace and the like, you may have to do a lot of testing to validate a novel alloy, but again, it could be reverse engineered. And I totally agree with Olga that data exclusivity is the answer currently in life sciences. But your premise is that all of these novel alloys and drugs are, in fact, you don't need to reverse engineer them. They're all obvious. There's no secrecy there, as it were, or no effective secrecy. And so I totally agree that what you're then looking at is other mechanisms to have sufficient monopoly periods to recoup your investment. Two other possibilities, though. One is that you get a market which is more like the internet boom, where people were using a non-inventive business model, or let's say a business model which by definition could be protected by a patent, and all they were doing was competing on speed to market and market share. Mm-hmm. And that was the route to success. And then the second option is that when all potential inventions become available, people will not be satisfied with an invention unless it's highly bespoke to their situation. And in that situation, it will be more of a one-to-one market where you are paying the compute time to get your bespoke invention for you personally, personalized medicine, for example, or you'd get an orphan condition in healthcare where they would crowdfund to get the compute and the clinical trial work done for their condition.
I hate to cut this short, but we have 15 questions and only 15 minutes left, even so I really, really apologize for having to cut all
Yeah,
this.
let me just say, Matt, I
I
think
mean,
those
we
are,
can work
those
with
are really good
overtime,
points.
not just
What?
that, you know, it's the request is huge, but the comments are amazing. It's extremely interesting.
Yeah, I'll just say to Matt, I think those are really good points. And, you know, there's a long history of discussion about non-legal modes of appropriation. And maybe we think those will work and we don't need a government role, but I think that's a conversation to have. But those are good points.
Then the next question is from Ron Marchant. Now, I know Ron spent a lot of his career with the UK Intellectual Property Office, but is, I think, retired now. Ron, what's your observation on this?
Very much so, and it's good to see Adam again. I think we met in Geneva several years ago. Oh, and you have my picture of Yosemite Park. Yeah, okay. I agree with the general framework of it, and particularly the wrap up, and that we do have to consider everything. For me, though, the fact that you're saying you can't tell inventions apart in terms of what the invention is invalidates the thought of parallel courses, because you're not going to know the route unless the applicant tells you the route. And we'll still be stuck with things like obviousness unless, as you say, everything's obvious, but I can't see us deciding the line between obviousness in the light of a machine invention or obviousness in the light of a human. As it was either Robin Jacob or Hugh Laddie once said, you don't get a patent for hard work, you get a patent for invention. So we're going to be stuck with what I regard as human-centered judgments in relation to what is creativity and inventiveness. And that will apply to all kinds of things, not just patents. It will apply to copyright and probably other areas of intellectual property too. So the dual track doesn't appeal to me as a way of solving anything. And in fact would have the problem that it would make the patent system less transparent, in my view, because you wouldn't just look at a machine and say, this machine has invented, is capable of inventing, and therefore everything it tells us is an invention and will be granted. But I go along with you that where we are cannot stand, and we have to do something. And I think, because I've believed for many years now, the most important aspect of the IP system is bringing stuff to market, not actually incentivizing people to think and invent. We need to tease out, and you've done some of that already, what it would mean if we had a patent system or an intellectual property system based solely on the value of the contribution or the prospective value of the contribution to society. What would that mean? And you've taken out the merit and value side deriving from human origin. And that might mean things in terms of term of patents, licensing agreements, perhaps even, and I hesitate to say this because the UK has always been staunchly against, you're almost suggesting the introduction of a kind of utility model system where in fact invention doesn't matter. But I go along with you in terms of something being done, but I just throw some thoughts about the complexity of it at you. I offer no solutions because, as Roya has said, I'm a retired jobbing bureaucrat, not an academic. No,
and I'm an academic, so I can just throw ideas out there. I mean, I agree with you that it's challenging, and we're just trying to. I don't know exactly how this invention machine certification would work, and maybe it's crazy, but it's trying to stimulate some discussion about what's at stake.
There's the next question from Matt. No, we got that from Shank. No, wait here, Nigel Worth. Nigel, please unmute yourself.
Thank you, Professor. Professor, it's extremely intriguing to listen to you, and the first time I've had the pleasure. I know time is short, so I'll come straight to the point on this. It's actually a little outside the box because it concerns a definition of what you have described as a machine rather than AI. And of course, you may be aware of revelations in the press only the last week in regard to separated neurons being capable of independent, shall we say, not thinking, but activity which suggests that they are learning to dispose of tasks in an enhanced way. That is a revelation which has taken us by surprise. And to the extent that it might suggest even hybrid consideration of what the word machine might mean. Because if those neurons were not effectively embedded in a human brain and yet still capable of manufacturing ingenuity, it leads to a whole new world of understanding.
Yeah, and I agree with you completely. And my use of the word machines was intended to be not limiting. I chose that word to just mean anything that's not like just a normal person. And I don't know what is in that set. And that was intentional.
Thank you.
Thank you, Nigel, for the great questions. So our next question comes from Sheng Xing.
Yeah, thank you. Professor, I actually have a question, but before question, I would like to show one point. If you assume that the machine can, from your presentation, I have a mind that the machine can discover all the knowledge that we have, then what's the marketing doing is actually to assign another machine to find the best portfolio of the patent and to make the market. But then it will be a very tricky question because there always can be a good machine to find the best, the portfolio. Then maybe our future may into a anti-utopia because, as long as they have the best algorithm, then they can find the best portfolio and they will occupy all the market. This is kind of my feelings. Okay, but my question is actually about how the patent office, how could they try to deal with this, the flow of the patent applications? Yeah, finish.
So your question is, how are they going to deal with the flow of the patent applicant? Well, I don't know. That's kind of the $64,000 question we say in the US. I think we're going to have to come up with some new. My tentative conclusion is that we're going to have to come up with some new ways of thinking about what it is that we do when we give people exclusive rights over technologies, because the existing way of doing it is probably going to break if we do come up with machines that can, or if or when, depending on your perspective, we come up with these machines.
But actually, the exist of the patenting process actually is try to align with the legal system and to ensure that this patent can really make some social benefit. It will sometimes be really hard for the, invention machine to ultimately to ensure the social value, especially when it's related to the ethics, the stuff.
Yeah, I think it was Ron who mentioned earlier that the existing patent system isn't about social value; it's about priority. And maybe one way to think about this new world is forget about priority and try to come up with a new system that really is focused on value, social value.
Wow. Yeah, we'll try. Thank you.
So Udo Junai, please.
Yes, it's. Am I heard?
Yeah.
Okay. So I have two ideas from that. The one is, I suppose that this great new world of everything invention has been made, and now we just have to exploit it, is, sorry, but a bit naive, because what you really need in order to get from a good invention to a real innovation is most of the time the enthusiasm of an inventor the power of persuasion of him or her that he can persuade investors and so on. And if you look at the current system, you have a lot of patents out there who are, let's say, offered for licensing for investors that they should develop something out of it. I suppose you know that this is not very, let's say, successful unless you have this power of persuasion of the inventor and so on. And I suppose that AI is really stronger in other fields than in persuading investors that this is the right investment out of many possible ones. So this is the first thing. And the second thing, actually, I find that the trend towards your proposals would be a trend away from kind of a democratic system where every bright mind has its chance to have his invention patented, to a world where big money is building big supercomputers, having them then checked whether they are invention machines, and then they produce it, and big money on the other side is taking it. And I think this is not really the system where creativity will flourish. Especially also not the creativity in exploiting the inventions.
Yeah. So let me respond to both your points. On your first point, I couldn't agree more. But my point is that no matter, while I agree that enthusiasm and vision on the part of an inventor and entrepreneur is necessary, it's not a sufficient condition. You also still often need investors, and you're not going to get investors if you don't have a property right of some kind. So that's what I'm trying to address. On your second point, I also agree. I think the issue of sort of the concentration of wealth and power, and does the IP system make that worse, is a big issue. I would just argue it's there no matter what we do. We can't make it go away by just ignoring it. So we should think about that and try to think about how to create a system that produces the results that we want, rather than just how to fit this new thing into the existing system.
The last question that came up, which was typed in, was, do we need to think about that already now? Because it will take at least 75 years until we're there. That this is really possible. Is this like an imminent problem just right now?
I think that's a great
energy crisis.
I think that's a great question, because frequently I get the opposite question, which is people say, well, it's going to be a long time before the invention machines are really good enough to make any difference. And then my response is, yeah, but it's going to take even longer to change the patent system. So we should start thinking about it now. So that's my view. I don't know exactly how quickly these machines are going to develop, but it will definitely take a long time to change the patent system. So we should start thinking about it now.
Okay, thank you. But I think we cracked most questions. This was amazing. I can't make up my mind if I enjoyed your talk more or the questions. I think it was just both coming together, which was fab.
This was really interesting to get the different perspectives. Thank you very much for listening to me, and then for commenting.
Yes, thank you, Professor Jaffe, for your contribution, and thank you, dear audience, dear participants, for joining us for this talk, which we announced at a very short notice. I was really happy to see such an intense debate. I think the core of the gist is, what do we want the patent system to be, and why do we want the patent system? And where's the patent bargain, and does the patent bargain change the moment you introduce AI as an inventor? But for this, I mean, what I have seen is that whatever the patent bargain should or should not be is an inherently political question rather than an economic or legal question. And that's where we need to start. And even if AI generated inventions made each other in AI as inventors of patents may still be down the line, I think there's way more work that needs to be done on why the patent system, what for, and how can it serve best humanity rather than the other way around. Probably also what I thought is the moment you have patentees being AI, you probably will have in the patent office also a lot of AI to assess such AI patent applications. But the gist of the issue remains the patent bargain and the increasing internationalization of economic activity. And what a lot of the crises we have seen, the COVID pandemic, climate crisis, really keeps on asking us, is the patent system really living up to what we want it to be? Will that change with AI, or how will we overload the system, or will the system just be able to cope? Completely unclear. I think you were extremely charming by saying some patent offices may be overwhelmed with the applications. But yeah, no, and so for those who came late, this was an Oxford webinar. In case you could see the logo here, we'd be happy if anyone is interested in giving a webinar talk, writing a short paper. Get in touch. We'd love to hear from you if you want to discuss with us anything around the economics of intellectual property or competition even. Get in touch. We are happy to exchange further. The moment we're running a huge research project on the patent bargain and what we can do to assure adequately the public interest and what this means for the practical management aspects and IP business strategy. With all of that being said, thank you once more. This was amazing. Have a lovely afternoon. We should have a new webinar coming up in 2 weeks, I think, and please be with us in November. There are lots of discussions, debates around the Unified Patent Court going to happen, about the judges for the UPC, the system of the UPC, the mechanisms of the UPC. We are all over UPC, Unified Patent Court, and we're also going to have quite a bit of debate again on patent damage calculations all over the world. With all that being said, again, thank you very, very much, Professor Jaffe. You know, in the real world, we'd now have a nice dinner together and a lovely chat, but in the virtual world, that's kind of like the fun part is kind of like taken out of this. So next time you're in Europe or I'm in the US, we have to catch up on this.
That'd be fun. We'll do.
Thank you once more.
Okay, thank
Bye.
you. It was very
Have a
interesting.
nice afternoon.